Delhi High Court is hearing a plea moved by a convict in the Nirbhaya case against the death warrant issued to him. The court, while hearing the plea, asked the convict why didn't they move for curative and mercy plea in 2017? Why was this plea moved after 2.5 years since the death warrant was issued? The High Court also said law only provides a reasonable time to file curative and mercy plea. Our Deputy News Editor Meenakshi Bhanja on the phone line getting us those updates there. Meenakshi, the hearing is still underway at the Delhi High Court. Can you take us through the details of what is happening inside the court?
Well, Apurva, we can tell our viewers that this process to keep the entire cycle in a loop will continue. And that is what we are seeing play out before the Delhi High Court Division Judge bench, two judges bench, where Rebecca John, who is the topmost defense counsel, is arguing as to how the 14 days period should be calculated post the disposal of the mercy plea by the Honorable President's office. She is essentially making the point as to how the mercy plea has been moved just yesterday, and it is getting effected by the impending execution warrant, to which we heard Honorable Justice Manmohan make that observation which you just referred to, where he said as to how subsequent to the rejection of the criminal appeal in 2017, why was the curative and the mercy pleas not moved back then? What were the convicts doing for 2.5 years? And the law only provides for a reasonable time to file curative and mercy pleas. Of course, the matter is still underway, where as we speak, the ASG, the Additional Solicitor General, who is representing the state, is saying that 14 days period is not what even the Delhi jail manual envisages. It grants only 7 days period. So clearly, these are last-ditch efforts being made now by some of the counsels representing these convicts to delay the inevitable, Apurva.
Also, Meenakshi, if you can quickly take us through what have been the arguments made by the defense counsel, especially when the court is asking why they didn't move for a curative or a mercy plea in 2017. Why is this plea being moved after 2.5 years since the death warrant was issued?
Well, they're saying that anybody who is even a death row convict is entitled to legal representation till the very last moment. They're also saying as to how the Supreme Court has not made any comments or observations about the delay in filing of the curative and the mercy pleas, and how the filing of the mercy and the curative pleas, although it may have happened 2.5 years later, it is still not barred by the statute of limitations. So purely a lot of academic arguments being made. Of course, as one can, see that the execution warrant is looming large on the horizon, and we will be seeing in the foreseeable future a slew of filings. We saw that yesterday also play out in the Supreme Court when the curative petition dismissal order clearly states in the first sentence as to how the stay on the execution, as was sought in the curative, is being rejected by the Supreme Court of India. But despite that, this matter was filed in the High Court.
Okay.
So various judicial forums will be approached at this juncture because they will want to try every last-ditch effort, as we said, to delay the inevitable.
All right, we'll have to leave it there, Meenakshi. Many thanks for joining us with those updates.